Hello, XRP fans. Welcome back to Crypto Maways. This is the place to be if you're interested in everything related to XRP and other cryptocurrencies. Make sure you stay until the end as you don't want to miss out the settlement of Ripple and SEC. Is the settlement real? Let's get into the video. Before that, if you are new here, please hit the subscribe button, you'll not regret. Okay, so the most recent update in the ongoing XRP lawsuit represents a possible twist regarding former SEC executive William Hinman's deposition. As part of a deliberative process privilege dispute, Garlinghouse's counsel has filed a motion to seal exhibits. Parts of William Hinman's deposition transcript were among the most important documents used by Ripple to win the lawsuit. Background of lawsuit: a startup called Ripple Labs first appeared on the fintech scene 9 years ago with a promising plan to provide financial institutions with fast, low-cost clearance of cross-border money transfers. To make it happen, the company established a network on which transactions could be sent across the globe in the form of a cryptocurrency called XRP, which was created specifically for the purpose. However, because of its eventual popularity outside of that application, XRP has proven to be a ticking time bomb with a very long fuse for Ripple. Last year, the SEC filed a lawsuit against Ripple and its current and former CEOs, alleging that selling XRP constituted offering of an unregistered security. Ripple's legal woes have become emblematic of the murky regulation enveloping digital currency, reflecting the mismatch between laws largely developed during the Great Depression and today's burgeoning fintech ecosystem. While opinions differ on whether the SEC has a strong case against Ripple, almost everyone agrees that the underlying issue is a lack of clarity about how cryptocurrency can be regulated in ways that do not sabotage the industry or unfairly target companies and investors who may have had little way of knowing they were in trouble with regulators. It's been more than a decade since this new asset class has existed, and we've yet to begin focusing on creating regulations tailored to it, said Carol Goforth, a law professor at the University of Arkansas who studies cryptocurrency. Here's why crypto investors are paying close attention to this case and what it could mean for the rest of the industry. Is Ripple looking for a settlement with motion to seal? Ripple confirmed that the defendants discussed filing the exhibits under seal with the SEC. The SEC, for its part, has not objected. However, the SEC's review of the submitted material and final decision to request a seal is still pending. Furthermore, this could imply a possible internal settlement between Ripple and the SEC, where Ripple has agreed to file exhibits under seal in order to avoid further public scrutiny of the named SEC officials. Motion to challenge SEC's misuse of DPP. Following the preliminary motion to seal, Ripple's counsel filed a letter motion disputing the SEC's improper assertion of privilege, primarily deliberative process privilege, DPP. The SEC's misuse of DPP is filed over pending SEC documents that are relevant to the lawsuit. Ripple claims that despite 2 consecutive orders, the plaintiff has failed to produce critical data. When the requested documents are produced, Ripple counsel claims that the SEC's case against individual defendants for unlawfully selling XRP without registering it as a security will be dismissed. These documents will, in turn, highlight the SEC's uncertainty about the status of digital assets as securities. Furthermore, SEC claims of reckless XRP sales by individual defendants were dropped because Ripple was on fair notice that XRP was, in fact, a security. Documents withheld include 13 internal SEC communications directly related to the regulatory status of BTC and ETH, as well as Hinman's 2018 speech on ETH's non-security status. 63 emails containing rough draft of Hinman's speech, as well as 65 other case-related documents containing emails, attorney notes, and memoranda. Furthermore, the SEC has failed to produce 170 inter-agency communications as required by DPP. Despite the defendants' claims about the SEC's misuse of DPP, the motion to challenge it is accompanied by sealed exhibits that point the Ripple SEC lawsuit in the direction of potential settlement. SEC attacks from the flank. XRP is a security for its marketing. At the core of Ripple lawsuit, the SEC is desperate for Ripple's Slack messages, but the agency has yet to produce any documents that it is required to deliver. Tension rises as the deadline for the fact-finding period approaches on August 31st. The Securities and Exchange Commission has requested a pre-motion conference in order to compel Ripple to search for and produce relevant communications between Ripple employees on Slack, which could assist the agency in building its case against the blockchain firm. Ripple agreed to produce responsive Slack data, but now, in the waning days of fact discovery, suddenly refuses to do so on the basis of Ripple's mistakes in gathering that data, according to the plaintiff's letter. Yet, Ripple's relatively few Slack messages have yielded critically important information not contained in emails or other documents that the SEC has repeatedly used in depositions to refresh Ripple's employees' dwindling recollections. The parties have met and conferred on this issue and have reached an impasse, said Jorge Tenrero, the SEC's lead counsel. Ripple appears to have slowed its production of relevant information ahead of the fact discovery deadline, which is August 31, months after the SEC's refusal to hand over documents regarding the agency's views on BTC, ETH, and XRP, despite the judge's insistence. Ripple's data error and refusal to produce most documents has already been extremely damaging to the SEC. The SEC has deposed 11 Ripple witnesses, among other things, based on incomplete records of their communications. Ripple should be forced to search for and produce responsive messages from 22 of its email custodians for the reasons stated below. SEC's core contention. Ripple sold XRP as securities. The request for Slack messages goes to issue number 1, whether XRP is a security, and now we see a major part of the SEC's strategy. It is attacking from the flank and arguing Ripple marketed and treated XRP like a security and therefore it is. See footnotes on pg.4, attorney Jeremy Hogan commented. Mr. Hogan quotes the letter's footnotes, which state that this information is critically relevant to the SEC's core contention, in this case that XRP offers and sales are securities offers and sales. The SEC has had some success with this argument in the past, and it makes sense as a strategy because XRP is not a security in any substantive way. We will have to wait for Ripple's response before deciding whether the court will order the production of the documents, Mr. Hogan added. The deadline for fact discovery, this type of discovery, is August 31. The parties will then disclose their expert witnesses and have another month or two of expert witness discovery. It's not a game changer, but it's eye-opening because we get to see a major SEC strategy. The SEC's winning strategy, claiming that Ripple sold unregistered securities regardless of the true nature of XRP, is unsurprising. That was made clear by SEC Commissioner Hester Pierce in June, when she explained the agency's enforcement criteria. When we consider a crypto asset to be a security, we are implying that it is being sold as part of an investment contract. It does not imply that the asset itself must be a security. It denotes that it was sold as a security. We can predict a negotiated settlement between the SEC and the Ripple. Ripple could be asked to register XRP as a security and comply with the SEC's rules and regulations. Ripple could be asked to scratch XRP away. This could be a one-of-a-kind situation in which a potential token cannot be discarded. This has the potential to greatly benefit the financial world. The final scenario, we can expect Ripple to be asked to declare half of its platform as a decentralized platform. The majority predicts a settlement, but nothing has been officially declared. We are hoping for an official statement related to the settlement soon. Because of the volatile and speculative nature of the crypto market, predicting crypto prices is a difficult task. The end of the lawsuit would undoubtedly aid XRP's ability to excel at a rapid pace. Many experts believe that the price of XRP will rise. Experts have made reasonable predictions for high-potential tokens. This could be just the beginning of a bull run that reaches many milestones in the coming months. Simpson's prediction of $589 could be met in 2 to 3 years, followed by a price of XRP reaching the 5-digit mark. This could be very beneficial for investors looking to earn high returns on their investments. It is always advised to invest only what you can afford to lose. This is an accurate statement that should be remembered before investing in any digital asset. That concludes today's video. Let us know what you think about this in the comments. See you guys in the next video. Till then, bye.